Welcome to the All Rise podcast, Sunday Scaries. I'm your host, Christine, a civil litigator and personal mentor. Every Sunday, we'll tackle those dreaded Sunday Scaries together to demystify the practice of law and provide you with actionable tips and guidance to face your week ahead. So grab a cup of coffee, take a deep breath, and join me while we turn those Sunday Scaries into stepping stones towards your success. Let's get started. Hello everyone, welcome back to another episode of All Rise Mentors Sunday Scaries, where we tackle common challenges and the not so common nightmares that all attorneys face every single day. I'm your host, Christine Barker, and today we are diving into a topic that every attorney, including me, including you, every attorney on God's green earth is going to have to deal with at some point in their career, and that is dealing with difficult opposing counsels. The legal field can be adversarial by nature. When you encounter opposing counsel who are, quote, difficult, it takes it to a whole new level. It can feel like a never-ending battle of the keyboards. People are constantly shooting emails back and forth to one another, getting into personal digs, attacking your client, attacking your credibility, calling you a liar, calling out your client. And granted, we are in an adversarial profession, but there are some attorneys who just take it to a different level. And in the middle of those discovery disputes or negotiations, sometimes it can be difficult to kind of not rise to the occasion and kind of stoop to the level of that unnecessary disputes. So here are a couple of tips to help you maintain your professionalism, keep your cool, and handle those really difficult opposing counsels. So before we dive into the tips, I just kind of wanted to share with you a personal experience of my own. So like I said, I've been practicing for 20 plus years, all in civil litigation. So I'm constantly in an adversarial role with my opposing counsel. Now, my primary area of law is construction. And I will tell you, construction is probably one of the friendliest areas of law. There's a reason I don't do criminal. There's a reason I don't do family law. Those just, for me, that's just a personality that doesn't work. I don't have the personality for those areas of law. I like construction because for the most part, my clients are contractors who are running businesses, and they're in the business of building. They really don't want to be adversarial. They don't want to be fighting with other contractors, with their subcontractors, with potential owners of other projects, because at the end of the day, they do want to get more work and get more construction work. They just want these, legal issues that I've been brought in to help them deal with go away in the best way possible for both them, for the owner, for the sub, so that they can all move forward and continue to do what they do, build stuff. So I do find, though, that sometimes because construction is not adversarial, the lawyers that get involved are heightenedly adversarial. And maybe it's because, they're the hired gun. Their clients have to play nice, with potential owners, subcontractors, other generals for their own business. But then they get to hire an attorney and say, hey, look, you guys go wild. You guys fight my battle for me. It is easier sometimes to become like a keyboard warrior where you hide behind your keyboards and you're just shooting off nasty grams. Now, I can write a nasty gram just as good as the next person, sometimes better. But when you use that, and it can be a tool that you should use, but not for the sake of confrontation, not for the sake of just being confrontational. So let me give you an example. I'm actually working on a case right now where it is my client was hired as an interior designer, and they provided interior design services. And the plaintiff who is suing my client claims that my client was working as a general contractor without a license, a big no-no in California. You have to have a contractor's license in order to perform any construction-related work. I disagree that what she was doing was construction-related work. I believe what she was doing was exactly what she was hired to do, and that's interior design work. However, my opposing counsel, they are hired to advocate for their client. and their client believes that my client went beyond the scope of interior design and was doing and performing tasks that were general contractor related, and thus she needed a license and she didn't have one. Now, clearly we've got different ideas of what constitutes work as a general contractor and what doesn't. Where I am getting into a unnecessary adversarial relationship with them is we're meeting and conferring over discovery. And they don't like the responses that I've been providing. They're the responses that my client has certified and verified that these are true and correct responses. These are all the documents that she's been able to discover and gather and produce. We're not withholding anything from them, but it's gotten real adversarial where the emails back and forth are just low blows, and your client's obviously lying and you don't know what you're doing, and it's just gotten really it's gotten really difficult. And I'm working with an associate on the case right now, and I know it's bothering her that she feels attacked whenever she gets one of these emails. She feels like she's being attacked, and she is. And so her and I spend a lot of time talking about really some of these tips that I came up for you today on, and utilizing them in the best way so that we can continue to work through the issues that are being presented to us, and do it in a way where we're not kind of stooping to their level. So, and sometimes it's really hard, there's, especially when opposing counsel will attack personally my associate. I will mama bear like almost immediately. Like, look, I can groom and I can and mentor and I can bring along my team, but when I see somebody else attacking one of my associates or somebody on my team, that's when I kind of start to lose my control, and I've got to enlist some of these tips in order for me to keep a level head, and make sure that I'm responding in the most appropriate way and in a way that is not going to harm my client. So let's dive into some of the tips. So first and foremost, always remain professional and composed. It is really tempting to match their combative tone. But remember, your conduct does not only reflect on you, but it reflects on your client, it reflects on your firm, it reflects on your partner. So as an associate, I know it's hard to not take these things personally, because sometimes the attacks can be very personal, especially if you're inexperienced and opposing counsel is trying to exploit that and say, hey, you obviously don't know what you're doing, or why don't I talk to your partner, and kind of calling into question whether you're even qualified to be having this conversation with them. Don't take the bait. Don't rise to the occasion or stoop to the occasion. Responding with hostility only just escalates the confrontation. Try very hard to respond calmly with a measured response, and sometimes this can help de-escalate the situation. And it definitely will put you in a better light with your client, with your partner, with your firm, and we'll talk a little bit later, but with the court. So as best as you can, take a deep breath before you respond to anything that's inflammatory remarks, any aggressive tactics. Maintain your professionalism, try to stay calm, try and stay focused on the issue. I like to kind of go through if I get an email and it's just full of just, antics and aggression and just inflammatory things, I go through and I'm like, what are the things that I have to respond to for a meet and confer effort, potential law in motion? What are they actually, is there a question pending? And then answering that question and kind of trying to push aside all of the unnecessary fluff. And sometimes this can be hard to avoid those distractions, but as best as you can, some things I like to do is, if at all possible, I like to wait 24 hours before I respond to some sort of message like that. If that's not possible, I will draft up the response, and then I'll put it in my drafts, and I'll wait, as long as I can, at least an hour, maybe a couple of hours. Sometimes I will send it to somebody else to review. Hey, do I need to tone this down a little bit? Am I being too confrontational? Am I being too aggressive? Or you can send it to your boss. Hey, I was really ticked off by what this opposing counsel said. Here's how I want to respond. What do you think? Don't ask your partner to write it for you. give them something, because they need to know what it is that you're taking offense to. They need to know what button did this opposing counsel push so that they can later on, kind of help you work through it if it's something that shouldn't be triggering you, or they can come to your defense. So, I know it's easier sometimes just to flip an email over to your partner and be like, oh my God, this guy is just awful. Could you please take care of this? Or could you please respond? Or I don't know how to respond. Yes, you do. You know how to respond. It might not be the appropriate response, but you know how you want to respond. So draft up that email, and if you need to, send it over to your partner. Say, hey, this is how I want to respond. That gives you some cooling off period, right? Because now it's being reviewed by your partner. It also gives your partner an opportunity to weigh in. And sometimes I'll email back to my associates like, nope, good to go. And if you want me to send it, I'll send it. But definitely try and take that time and just kind of calm down a little bit, maintain your decorum, maintain your professionalism, and give yourself just a little bit of space between the time of getting something that's, super aggressive from opposing counsel and responding to it. Tip number 2, document everything. Keep meticulous records of all interaction with opposing counsel, especially if they are aggressive and they're super difficult. This includes emails, phone calls, meetings, any other communications that you have with them. Detailed correspondence and documentation can protect you and your client if a dispute ever arises and there's like a he said, she said kind of thing. If opposing counsel tries to mischaracterize something that you said in an agreement or in a conversation, having detailed notes and records can be a total game changer. It's a really good practice, too, to confirm all verbal agreements in writing. So you have a phone call with opposing counsel, you guys come to some sort of agreement, shoot an email off just to confirm this is just what we just spoke on the phone, here's what we agreed to. If this does not comport with your understanding, immediately let me know. That way you've got your detailed notes, you've communicated with the other side, and this ensures that you've got clear and accurate records. Always, this is really, really important, always assume that anything you put in writing may one day be an exhibit in court, that the judge, a jury, a witness, your client is going to see what you wrote in an email, in a letter, in a note somewhere. So just be aware of that. You don't want to be talking bad about your client to opposing counsel. You don't want to throw your client under the bus because you're trying to get yourself more time to respond to some discovery. You don't want to say, hey, my client's super difficult. I'm not able to get a hold of him. That's why I need another 3 weeks to respond to written discovery. Just be aware that potentially your client, a judge, a jury, a witness, your boss, opposing counsel is going to see that written communication. So just be aware of that. That's not to say you shouldn't be firm and that you shouldn't be forceful and you shouldn't be direct, but you need to do it in a thoughtful way. So and be aware that that is going to be read by somebody later on. Your words will come back to haunt you, so just be mindful about how you use them. Tip number 3. Try and set some boundaries. I've had one opposing counsel who would constantly call me after hours. He would call, 7, 8 o'clock at night. I don't know why this was his preferred time to chat with me, or if he just was busy all day long and that was his only time to catch up on phone calls. But it became a problem because he would call, after hours while I'm, having dinner with my family, while I am, with a client, while, I'm just trying to relax and decompress from perhaps maybe a stressful day. So it's really important to kind of set those boundaries. Make sure that you're clear on what behavior is acceptable and what behavior is not acceptable. This is not to say that opposing counsel isn't going to call me after hours. He continued to call me after hours. I just made sure that he was clear that I would not be responding during outside of office hours, unless it's some sort of an emergency. But, I would get a voice message from him at 9 o'clock at night. The next morning, 8:30, 9 o'clock in the morning, I would respond, either by email or I would call and leave a voicemail message. Hey, got your message from last night, just so you know. I generally don't respond to voicemail messages, after 6 o'clock. If it's an emergency, obviously I will, but just so you understand, you'll be hearing from me the next day anytime I get a voicemail message from you that is after hours. Or I might shoot it in an email. just so you know, got your voicemail message. I'm available today until 3 o'clock. You can give me a call then. Also, in this day and age with technology, I've noticed that I'll get a lot of text messages from opposing counsel, from clients, from witnesses. I mean, sometimes I think it is just easier. It is a mode of communication that people on their day-to-day basis, that's how they communicate. I do not respond to text messages. They're difficult to extract. So if I needed to use those text messages as an exhibit to say a motion to compel, and my communication with opposing counsel was through text message, it just doesn't come out very professional. It doesn't come out very clear. People tend to be a little loose with their vernacular and grammar and things like that. So I just don't respond to text messages via text message. I will respond, I'll just respond by email. So I would put in an email to opposing counsel that received your text message yesterday. I'm responding by email. Please respond to this email. And then I'll go into whatever it is that we needed to discuss. But setting boundaries that don't text message me if you're opposing counsel. It just, like I said, it's just not very professional. And also it tends to get buried. You know, I don't know about you, but I've got multiple conversations going on with my sisters, with my husband, with groups of friends. And if I get a random text message from just a phone number, if opposing counsel's cell phone isn't saved in my cell phone, which it isn't most of the time, I don't know who it is. And sometimes, you know, they call cases by something else. We've talked about this before about, you know, having a clear subject line about what the case, you know, the case name and who your client is. But in a text message, you can't do that. So, like I said, that's a boundary for me. I don't generally take calls from opposing counsel after hours, and I don't respond via text messaging. But I will respond, I just do it in a more appropriate mode of communication. Tip number 4, utilize the court's authority. So don't be afraid to enlist the help of the court when it's necessary. If opposing counsel's behavior has gone across the line, it is unethical, it's abusive, we're now entering that abusive territory, you can and you should bring it to the attention of the court. Judges usually do not tolerate unprofessional conduct, and well-documented records of such behavior can really prompt the court to take action. So I'm not saying run to the court every time opposing counsel hurts your feelings. I mean, we do have to have some thick skin here. We're in a adversarial profession. But there are times when that behavior does cross into the abusive territory, and that is a good time to bring it to the court's attention. This might include, things that the court has power to do is sanctions, seeking protective orders, using the court's authority to help curb the opposing counsel's conduct, and bringing the focus back to the legal issues at hand. And before getting to the court, do enlist your partner. As the associate, it might be difficult sometimes, especially if opposing counsel is more experienced. They're trying to exploit your inexperience. Sometimes it's, you do need to bring that to the attention of your partner. So like I said, they could be the one to send off the email. If somebody is being offensive to somebody on my team, I will jump in and I will make sure that I am advocating not only for my client, but for the professional and appropriate behavior towards people and members of my team. Of course, I'm not going to do it if I think that you know what you're doing or you can handle your situation. I'm not going to come running in, like the overprotective mom. But bring it to my attention, bring it to your partner's attention, even if it's just to bounce ideas off of, or if it's time for opposing counsel to hear from the partner that their behavior has gotten to a level that is unacceptable. And finally, tip number 5. Focus on what's important. Always focus on what you've been hired to do in the first place, and that is to advocate for your client. So keep your client's best interest in mind. It's easy to get caught up in personal dynamics and attacks and all of the drama of a difficult opposing counsel. But remember, your primary duty is to keep your client's Your primary duty is to keep your client's goals and best interest at the forefront of your scope. And so making sure that you are constantly looking for ways to strategize and to advance your client's position and not getting caught up in the tit for tat that a difficult opposing counsel can do. A lot of times they do it on purpose. They do it to get a rise out of you. It's kind of like the shiny object over here. Pay attention to what a jerk I am so you don't pay attention to, mistakes that their client may have made. You don't pay attention to the lack of evidence that they might have. It is a tactic, and it does work sometimes, that counsel will just be so difficult that you're like, look, I just don't want to deal with this attorney anymore. And you then wind up going to mediation, or you wind up settling the case for more than it's worth, just for your own sanity and your own peace of mind. Keep in mind and know that that is a tactic of theirs, and see if you can spot that when you are stepping back and objectively looking at the antics that are being pulled. By staying focused on achieving the best possible outcome for your client and not letting opposing counsel's tactics derail you, but you kind of keep your eye on the prize, know what you're hired to do, and then you can navigate some of these more challenging conversations and difficult personalities, because they're out there. We're all going to have to deal with them. Just try and make sure you're not one of them. All right, so there you have it, our top 5 tips for dealing with difficult opposing counsel. Remember, stay professional, document everything. Set those boundaries for yourself. Use the court and your boss authority as appropriate and as necessary, and then always keep your client's best interest right there in the forefront. And these are the best tools for you to help navigate those difficult circumstances. Thanks so much for joining us. Stay tuned for next week's episode of All Rise, Sunday Scaries. If you found these tips helpful, please do subscribe. You can like, you can share, you can let your friends know. We do have our pre-registration still going on for our new attorney training. Check the QR code below if you'd like to find out more information. Until then, it's not as scary as it has to be. These little tips will help. So thanks so much. We'll see you next time.